This event today is organized by the Law Clinic of the University of East London. We do host these types of events because we think that members of the public and our students and our staff, they do have the opportunity sometimes like this to learn about the law, and the law in simple terms, in simple language. And so we believe that the project which we call Know the Law is part of these activities. We do so for a number of reasons: to disseminate the law, to engage with members of the community, because that is what a learning institution like this should do. And it also gives our students the opportunity to organize events like this and interact with members of the profession. And so we hope that when we have the light refreshment at the end of the session, you will make yourselves comfortable and engage with our students and our staff. We hope that you will be able to take something from this lecture. Bear in mind that we have a very learned speaker who is going to address us, especially those of us who come to institutions like this, post-1992 institutions. We've come a long way, and we believe that we are now part of the mainstream of learning and education in this country, and we believe that as an institution, a post-92 institution, we are very proud of our heritage, we're very proud of our history, and we're very proud of what we can do as a learning institution contributing to the education of citizens of this country. So we hope that you will learn something, you will benefit something, and please remember, this is a place of learning, and if you think that this is a place wherein you want your sibling, your sisters, your friend, your relatives to come and learn, please do so, because you will get something of this nature. Without much ado, I would want to call the Dean of our school, Professor Matthew Humphrey, to take the podium because he will chair this event. Professor, please.
Thanks very much. Thank you, Patrick. Hello, yes, I'm Matthew Humphreys. I'm the Dean of the School of Business and Law, and I want to formally welcome you to this event. The School of Business and Law at the University of East London is a newly created school. It was established in September last year, so this is our first full year of activity. The programmes in law and business have obviously operated for a number of years, so we've got a long history and a great pedigree. One of our alumni, a very celebrated alumnus, is going to speak to you at the close of the event. You're very welcome to this event today in this fantastic facility here at USS. It really is state-of-the-art facilities, and I would strongly encourage you to consider University of East London and this school as a place of opportunity and for study for you, for your family members, for any of your the people in your local communities. The school has got some very well-established programs, as I just said, and we also want to look at kind of the links between law and business. I think that's the kind of future, and so we've got great prospects coming. Now I'm going to say a few more words in a minute about our very distinguished speaker tonight, but I'd also like to introduce our Vice-Chancellor, who's going to say a few words about the university's strategy for civic engagement.
Thank you very much, Matthew, and welcome to everybody. And welcome to this fantastic building. If you haven't visited us before, this is University Square, Stratford, that was opened by Princess Anne a couple of years ago. And it's the home, as Matthew said, of our law school. Our law school has been established for a long period of time here in East London. Now, Matthew said that, I was going to say a few words about UEL and about our new corporate plan, which we launched last week at the House of Lords. And it's our 5-year plan to be London's leading university for civic engagement. Now, civic engagement means different things to different people, but for us, we're an anchor institution in East London. And one of the things that civic engagement means for us is that our students actually get involved in their community. They become active citizens and change agents, and they make a difference. They help to transform their community and also act as role models and leaders of their community for the future. And this series of lectures exemplifies that, really, because it's really developed out of our fantastic initiative, the Pro Bono Law Clinic. And Pro Bono Law Clinic and we're very proud that Imran Khan is here, an alumnus of this institution, and also the patron of the clinic, and he'll say a few words towards the end of this evening. The Pro Bono Law Clinic offers free legal advice to the people of East London. What's wonderful about it is that it's our staff and students working together with local legal practitioners to do that. And for our students, it's an example of what we call an engaged curriculum. And it means our students aren't just focusing on seminars and lectures, they're actually getting engaged in their discipline, and in this sense, by offering free legal advice to the people of East London, doing something that's a real asset for this institution and for the community. So, as I say, the Pro Bono Law Clinic is just one example. There'll be a number of other pathway projects that you'll see in the months and years ahead that exemplify this approach. We see East London as a very exciting place, a living lab for all sorts of things. But East London also is a bit of a city of paradox. It's undergoing enormous transformation in the next 5 to 10 years. More inward investment coming into East London than almost any other part of the UK. At the same time, East London is still probably one of the most deprived areas in the UK. And as an anchor institution, we are committed to making sure that in the next 10 years, the people of East London, and many of them come here as our students, the people of East London get the opportunities that they deserve, and we will help to shape and transform the future of East London in a really positive way. And that's why we're going to be London's leading university for civic engagement. Thank you very much for coming. I'm absolutely delighted that we've managed to attract the Right Honourable Lord Neuberger, apparently just by writing a letter to him. So there you are. It can still work. It's a real coup for us, and we're absolutely delighted. And I know Matthew will do the introduction, but I know that Lord Neuberger also has a lifelong commitment to widening participation and fair access, and he'll say something about that tonight by the look of his talk, and I'm really interested to hear about that. But it's particularly apposite that he should be here, I think, to deliver this type of lecture as part of our civic engagement series. So thank you for coming. I'm going to pass back now to Matthew to do the main introduction, and enjoy the evening. And please do stay on after and have some refreshments and network. And if you are a local legal practice or even a distant legal practice and you want to get involved in the Pro Bono Law Clinic, just come and speak to either Matthew or me or Patrick and Nicola, and we'll facilitate that pretty quickly. Thank you.
Thank you very much, Vice-Chancellor. Okay, so Lord Neuberger is, as mentioned, he is the President of the Supreme Court of the United Kingdom, and he is known then particularly appropriate for fronting this evening on behalf of the Law Clinic. He has done some outstanding work on widening access to the legal professions and on fair access on a project led by Alan Milburn. He's very well-regarded and preeminent career. He's educated at Westminster School and at Christ Church, and has worked at Rothschild's, called to the bar in 1974. Within 20 years, made a venture for Lincoln's Inn, and appointed Queen's Counsel in 1987, with his first judicial appointment as a recorder, I think in 1990. In 1996, he was appointed to the High Court Judge in the Chancery Division and was the supervisory Chancery Judge for the Midland, Wales and Chester and Western Circuits from 2000 to 2004. And then in January 2004, he was appointed as the Lord Justice of Appeal. So, since 2007, he's been a Lord of Appeal in Ordinary, a Law Lord, and was then given a life peerage, and has done the work, as just noted, on fair access and widening access to the barrister profession. Okay, can I now please formally then introduce Lord Neuberger for his lecture.
This evening. Before I talk about them, let me explain that I thought one speech about one subject can be a bit boring. So I thought I'd try and cover 4 items, and in a rather tired attempt to link the topics in a title which sounded reasonably short, I tried to social and moral issue, namely the importance of diversity, ethnicity if you like, but not by any means only ethnicity. And thirdly and fourthly, 2 legal topics, which are both highly topical, connected with Europe, the EU and EU law, and human rights and human rights law. What I propose to do is to start with diversity, move to the 2 European topics, which are more, if you like, to do with hard law, and then to end with education and training. Now, when it comes to diversity, there's gender diversity, there's ethnic diversity, there's age diversity, and those are relatively easy to measure and to identify. Background diversity, the need to include more people from less privileged backgrounds and perhaps fewer people from more privileged backgrounds, is the most challenging aspect, I suggest, of diversity in the United Kingdom, partly because background prejudice is difficult to identify, and partly because reliable evidence is quite sparse. You can tell if someone's a man or a woman, if someone's old or young, what ethnic background somebody has, but it's more difficult to identify disadvantaged backgrounds and advantaged backgrounds. But in some ways, most importantly, background unfairness is the most difficult to deal with because its causes are so ingrained in society. And of course, I haven't mentioned sexuality diversity, which I don't think is much of a problem in the legal world. And then there's diversity in the sense of full access for the disabled, and, well, where there's a significant amount to be done. Now, on the whole, in this part of my talk, I propose to concentrate on gender and ethnic diversity, but that's merely because there's solid evidence in relation to them. But the other areas of diversity are equally important, of course, and much of what I have to say applies to them too. I think diversity can be looked at, if you like, in terms of principle with 2 questions in mind. The first is, why should we do anything about it? Why should we worry about diversity at all? And secondly, what can we do to improve it? Well, why is diversity desirable? Whatever type of diversity one's talking about, whatever one's talking about a fair access for every group, we all accept it's a good thing. But it is worth considering why it's a good thing. First, I think it's simply unjust that people should have fewer opportunities in life because, for instance, they are women rather than men, or because they are Asian rather than European in origin, or because they're privately educated rather than publicly educated. Secondly, an unrepresentative institution risks losing public confidence. For instance, a set of chambers, a firm of solicitors, a group of judges, which consists only of white public school men, may very well lack credibility to some people, particularly, of course, the women, ethnic minorities, and the less privileged. Thirdly, and importantly, which is often overlooked, I think, if the most important jobs are in practice not equally open to everybody, then it seems to me that as a matter of elementary statistics, it means that the top jobs are not going to all the best people. And that reduces the quality of the people in the top jobs, and that's bad for the country. And finally, I think diversity of people in jobs leads to diversity of outlook, and that's very valuable in all walks of life. And I think each of these 4 reasons is of particular importance when it comes to the legal profession and the judiciary. The reason for our existence as lawyers, as judges, is upholding justice, fairness, and the rule of law. And if we are not meritocratic, how can we expect it of others? And given the importance of the English legal system to the economy, we must maintain our reputation for excellence. And diversity of outlook helps to ensure that the law remains relevant and respected generally. Social fairness, the rule of law, a healthy economy, and a respected legal system all seem to me to add up to pretty convincing reasons for promoting diversity. But there is another reason, I think. Women and those from ethnic minorities and members from other disadvantaged and minority groups should show and be enabled to show that they belong to, they buy into, that they feel part of the system. Just as society benefits from a properly diverse legal profession and diverse judiciary, so do members of minorities benefit from being in the legal profession and in the judiciary. And the benefit is not merely for the members of the minority group themselves, but for society as a whole and for the very minorities from which they come. It's vital, I suggest, that all groups feel and genuinely are included in UK society at all levels, and that they feel genuinely included in society at all levels. I'm not suggesting we should lose our identity if we're members of minority groups, but the very word diversity suggests that we keep our individual characteristics, that we don't suffer as a result of them, and society benefits from them, the whole country benefits from them. Now, in the legal profession and in the judiciary, we have to, therefore, to do our best to improve diversity. But I think it's sensible to face the fact that there are problems in that exercise. I don't mention that to be defeatist, but so that we can be aware of them and overcome them. Any lawyer who's argued a case knows you're much more likely to succeed in arguing your case if you acknowledge the problems which you face, know your enemy. I think there are two reasons that we face a problem. The reason why women, ethnic minorities, people from less privileged backgrounds and so on are underrepresented, often in some areas grossly underrepresented in the legal profession and the judiciary, are largely due to the inequalities, the unfairnesses, the structure of society generally. And that, of course, means that we are fighting not merely to improve what happens in the legal profession, but we are fighting to improve the structures generally, and they start, of course, at a young age for people. Secondly, I think we live in rather challenging times for improving diversity. In the 25 years or so until 2008, until about 7 years ago, the economy grew pretty consistently. There was a large expansion in university places, and there was an expansion in prestigious jobs. So the possibility of a relatively painless increase in diversity at the top was there. And while some progress was made, it was not very impressive. With an economy that's expanding more slowly or in some areas contracting, improving diversity will be more of a challenge. But those difficulties, the structure of society and the fact that we have a less benign economy, certainly do not begin to justify us doing nothing. On the contrary, I think the legal profession and the judiciary, with their privileges and their responsibilities, based on their role in the rule of law, have a duty to lead and show the way, and by example. When I became a barrister in 1974, the legal profession was very white, male, and privileged. Over the past 40 years, things have improved on the gender front, both at the bar and among solicitors and among judges, but only to a limited extent. Women represent around 52% of law students and about 45% of trainee barristers and solicitors. But only 32%, so it goes down from 50 students odd to 45 apprentices to 30 or so practicing, and only 13% of QCs and top solicitors are women. So you have a pyramid, if you like, as a percentage of women, starting at more than 50% at the student level, and at the top of the legal profession a little bit, but only a little bit more than 10%. As for ethnic diversity, 11% of practicing barristers are BME, but only 5.5%, exactly half the proportion, are QCs. So again, you have this tapering effect on the way up. Background diversity is, as I've mentioned, difficult to measure, but I don't think it's much better than it was 40 years ago, but it's a bit better. So we're going in the right direction, but I think things are going more slowly than one would hope. And what about my lot, the judges? Well, so far as the senior judiciary, the High Court judges and above, are concerned, the position is pretty similar, not surprisingly, because High Court judges tend to be selected from the top lawyers. We've gone a significant way. The first woman High Court judge ever was appointed less than 50 years ago. And when I started 40 years ago, there were, I think, one, possibly two High Court judges. Now there are well over 20 High Court and Court of Appeal judges who are women. So the proportion of women in the senior judiciary has increased to about 20%. Not great, but moving in the right direction. On the social background front, the judiciary are doing better than they were, but I'm afraid ethnic diversity among the senior judiciary is very bad. It's better in the more junior judges in relation to both women and ethnic minorities. 25% women, 25% of circuit and district judges, the more junior judges, doing equally important work, but in the county courts and the criminal courts. 25% of them are women and 6% BME. And if you go to the tribunals, who are the people who deal with tax cases, with employment cases, with social security cases, and so on, then 45% are women, a good proportion, and 13% BME, which again is not an unreasonable proportion. Now, I've already identified the tapering off of women and ethnic minorities as one goes up the ladder, which is a problem for both solicitors and barristers. It's a problem of the legal profession. You used to be able to come up with the excuse that relatively few members of minorities were at the top because that reflected the intake 20 or 25 years ago. But I think that explanation no longer works, because looking at the intake 20 or 25 years ago, there were many more women coming in than are now in proportion at the top. And the same, as I mentioned, is true for the ethnic minorities. The problem, I think, for women, at any rate, in the legal profession, arises from the fact that many of the law firms and barristers' chambers require a virtually 24/7 commitment from their lawyers. Lawyers with family and other responsibilities almost inevitably work less, and therefore don't carry the same weight, the same heft, aren't seen as important as those sad people who have no life but their work. And in our society, of course, it's far more common for women to have the family responsibilities. What's needed is a change of culture to some extent, which is easy to say but quite hard to achieve. It would be wrong to undermine the effectiveness of the legal profession, which does very well in this country in many ways. But pressure from clients could prove effective. In some US large companies won't use law firms unless they're satisfied that they promote women and ethnic minorities, and we could do with that here. I think also, in order to improve things, it's not just a question of concentrating on women or ethnic minorities and improving their lots and ensuring that preconceptions are changed. It's just as necessary to concentrate on men and on white people, until it becomes entirely unremarkable for men or others to take an equal share of caring responsibilities. There's little hope of achieving genuine equality of opportunity. And I think that's starting to happen. I think looking at my children, all of whom are lawyers, and their partners, they are far better than I have to admit I was 40 years ago at sharing out their responsibilities. And I think your generation, which is mostly even younger than my children, will probably do better than my children, and my children have done better than me. But we must foster a culture which renders it just as acceptable for men to look after children and look after the house as it is for women. I think that improving background diversity raises a more fundamental problem. If you come from a less privileged background, you're likely to be disadvantaged both in terms of social confidence and awareness, and in terms, in some cases, of education compared with someone from a privileged background. Private schools, there are some lousy private schools and some very good state schools, but on the whole, I think that you do have advantages if you come from a privileged background, and maybe they're mostly social. It's understandable why a firm of solicitors or a set of chambers would take someone who has a first-class background with an academic record which is very good, which was very easy to achieve relatively if they come from a sort of professional and privileged background, rather than taking an applicant with a less glittering record, but who actually is much more impressive because he or she had to overcome a more challenging start to life. And I think that lawyers, firms of solicitors and sets of chambers owe a duty to the rule of law, to society, and indeed to themselves, to think imaginatively about that sort of issue. They should be seeking out bright people, able people, who, despite their relative disadvantages in terms of background, have done well. And it's difficult to measure somebody with a less easy background, a less easy life, and their achievements with somebody who comes from a much more privileged background with perhaps slightly better achievements. But I think it's something that has to have to be done. And I think it's fair to say that many firms of solicitors, many sets of chambers are consciously trying to do something in this connection and really achieve more diversity. There are obviously various things they're doing: mini pupilages, placements, mentoring, school visits, university visits, moots, that is, mock debates, which take place, organised either by courts, I'm judging one tomorrow as it happens, and also talking to people, coming out talking to you, but in many ways one-to-one is even better. I think it's undoubtedly the case that almost all firms of solicitors, almost all sets of chambers, almost all groups of judges want to be more diverse. But it's one thing to talk the talk. They have to walk the walk. So far as the judges are concerned, people from less privileged backgrounds among judges, and they've done pretty well. I think that we have to look at, we have mentoring schemes, we have to look outside the more traditional places for recruiting judges, and they've done that. More academics, more employed lawyers being appointed. And I think that is starting to happen. And we're also starting to have part-time judges, 50% time, 60% time, and recently they changed the law, so my court, the Supreme Court, can have part-time judges. Early days yet, we haven't got anything but we will have in due course. One hot topic which is discussed is whether or not we should have quotas in order to achieve what we are so slow at achieving, which is a higher proportion of minority groups. I've always been against quotas, but and even now, although I can see the argument, I still think it would be a mistake. I think it could be undermining for those people who get appointed, knowing that they may only have been appointed because there's a quota system. And I think it also would act unfairly on others who are not minorities, who may be better appointees. But at least we have a system now whereby if you have two candidates who are equal, the one who is a more diverse appointment will get appointed. That leads to a lot of legal type arguments, as you can imagine, about what is meant by equal. But nonetheless, it is a step in the right direction. Having talked about law, let me turn now to the very different topic of Europe. Now, as you will all know, there are two important different influences on UK law from Europe. There's the European Union law and the European Convention on Human Rights, the EU and the Convention. They used to be entirely separate, but they're getting closer. The Convention, of course, is concerned with human rights, or as some prefer to call them, fundamental rights. Privacy, free speech, freedom from torture, freedom from discrimination, and so on. A sort of moral and political venture. Historically, the EU, on the other hand, was concerned with removing trade barriers between European countries. So it was primarily an economic venture, single market, freedom of movement for goods and people. However, over its lifetime, the EU has become more directed towards a political union. This change is reflected in the change of name since the United Kingdom joined the EU 42 years ago, before most of you were born. In 1973, when the UK joined the European Union, it was known as the Common Market, which suggests a market, an economic exercise. It's now the European Union, which suggests a more political exercise. Some might think that this development, resulting from lifting of economic barriers, was an inevitable consequence of the notion of a single market. But whether or not that's right, over the past 20 years, there's been increased cooperation on non-economic fronts between EU member states. And now the EU has a Charter of Fundamental Rights and Freedoms, which has a strong resonance for anyone who is familiar with the Convention. Now, the UK signed the Convention on Human Rights as long ago as 1951. But the Convention remained an international treaty. It was not something which really influenced the English law much. In 1998, Parliament passed the Human Rights Act, and that, as it were, made the Convention part of English law. For the first time, judges like me not merely could apply the Convention and all its principles, we had to apply the Convention. And that has been a very significant influence, as anyone who reads the newspapers will see. But of equal significance, although less heralded in the newspapers, of equal significance to our law was our accession to the European Union, especially as the powers of the European Union have increased, most recently since the Lisbon Treaty some 10 years ago. Now, until the second half of the last century, there were two sources of law in this country: law from the courts, the judges, and law from Parliament, from Westminster. Now, following the Norman Conquest 900 years ago, when even I wasn't born, the great majority of the law was made by judges through decided cases. They laid down principles which, as you know, became the common law, judge-made law. But alongside the common law were statutes, originally laws made by the king through his council, and gradually, as Parliament took over from the king, acts of Parliament, statutes. So there were the two sources of law. But unlike most other countries, indeed almost all other countries that call themselves democratic, the UK doesn't have a constitution. It doesn't have a fundamental set of rules which enable judges to decide whether a statute is invalid on the ground that it infringes the Constitution. So with no Constitution, Parliament rules. We have what's called parliamentary sovereignty. The judges can develop the law as we see fit in accordance with the common law, but if Parliament steps in and passes a statute, that, as it were, trumps us. So if they don't like the law that we make, they can pass an act to Parliament, and that is the law. We can't then turn around, as the US Supreme Court can, and say, sorry, Parliament, you might have passed the law, the Queen might have stamped it, but it's contrary to our Constitution. We can't say that because we haven't got a Constitution. We're almost the only country in the world without one. So we have parliamentary sovereignty, and what Parliament decides is the law. There's a discussion among academics, which has been touched on in one or two cases by the courts, about whether the judges could actually overrule a statute if it was so outrageous. It remains to be seen. I hope we never have a statute that is outrageous, but if we do, we'll have to think about it. That was the position, and fundamentally it hasn't changed. But the effect of European Union law and the law of human rights has, in practice, changed it quite a lot. The effect of our joining the EU in 1973 is that we now have to apply EU law as English judges, and that includes applying decisions of the European Union Court, which is in Luxembourg, the CJEU, but it's the Court of Justice of the European Union. So if a decision of the European Court in Luxembourg says that European law, EU law is such and such, and it conflicts with a statute, we override the statute. So for the first time in our lives as judges, UK judges can override the statute and apply EU law, because that's what the Luxembourg court has decided. It overrules Parliament. Now, why that technically is not new law is because Parliament has decided that we should be able to do this. Parliament decided that we should join the European Union, and therefore Parliament, what Parliament decides, it can undecide, so it could pull out. So technically, it's not a new power for the judges, but in practice, it's quite revolutionary. The Human Rights Act has also had a revolutionary effect. One of its effects, which is in a way most revolutionary, is that we've been told under the Human Rights Act as judges to interpret statutes in a way to bend the meaning of statutes so that they comply with the Convention on Human Rights. So if we have a statute that Parliament meant to mean X, but we decide that if it means X, it will conflict with human rights, we have to try and make it mean Y. So we're really rewriting statutes. That's not a power which is much commented on in the papers because it's a bit technical, but actually it's rather an important power. It gives judges quite a lot of extra power. Again, Parliament's given it to us, they could take it away. The more famous power we have is if we can't make a statute comply with human rights because it just is so clearly not complying, even if we bend it, it still would apply. We have to declare that it's incompatible with the Human Rights Convention. We give a declaration of incompatibility, and then it's over to Parliament to change the law. And in practice, whenever we have said to Parliament, no, this won't do it, doesn't comply with the Convention when they've passed a statute, Parliament has always changed the law to reflect what we say should have been done, save on one occasion, and that is concerned with the question of whether prisoners should have the right to vote. It's a very hot political issue. The European Court of Human Rights in Strasbourg has said that Parliament should consider giving some prisoners the right to vote, and so far Parliament has said no prisoners should have the right to vote. Now, I said a moment ago that when it came to European Union law, EU law, we had to follow the decision of the Luxembourg Court. When it comes to human rights, we don't have to follow the decision of the European Court of Human Rights in Strasbourg. We have to take their decisions into account, but we don't have to agree with them and follow them, although generally we do. Now, these developments have a number of interesting features. First, given that we have a set of rules which govern our approach to law and protects individuals, that is the Convention, with its rights to free speech, privacy, the right to marry, freedom from torture, and so on, it's almost as if we have a constitution. You think about the First Amendment to the American Constitution, it's the right of the famous right of free speech, and so on. And that is something now we have in the form of the Convention. But because we still have sovereignty, we can't do what the American US Supreme Court would do, as I say. But we can tell Parliament that if they do something that breaches the right to free speech or the right to false imprisonment, they should change the law. We never had the right to do that before. Secondly, in any civilized society, if you give people rights, they must also have the right to enforce them. And people who want to enforce their rights only have one place to do it, and that's through the courts. And therefore the Convention has required the judges to step into areas of social policy, economic policy, moral policy at times, which had previously, according to the UK view of the law, not really been for judges to step into. So again, we have a more interesting, more difficult, and more varied diet. Thirdly, of course, we as judges have developed a UK human rights jurisprudence. We haven't just looked at Strasbourg. We have had to consider what Strasbourg says and develop our own thoughts appropriate for the UK. I think we UK judges initially were too ready to follow the Strasbourg court's decisions. Strasbourg had been doing human rights cases since the Convention came into force in 1951. We were the new kids on the block in 1998-2000, starting to learn about human rights. And to begin with, I think we tended to follow what Strasbourg said. But now we've become a bit more experienced, a bit wiser, a bit more self-confident. We are developing our own human rights jurisprudence. I think that in general, the developments attributable to the Convention coming into English law have been beneficial. Of course, there'll be arguments as to whether some decisions of the Strasbourg court were right. There'll be some arguments about whether some of our decisions are right. Judges do their best to get things right, but they don't always, any more than anybody else. But the rights which are embodied in the Convention are fundamental to the rule of law. And as you have an ever-increasingly powerful government, a very strong executive arm of government with more than 40% of the gross domestic product to spend, with millions of people, civil servants, local authority officials, and so on, the growing power of the executive means that the judges have to stand up for enforcing individual rights against wrongdoing by the executive. I'm not pretending that we have civil servants and other public servants who are corrupt or dishonest or wicked, but it's inevitable that with an enormous public service, enormous numbers of public servants, that individual rights will be endangered because they will be trampled on, sometimes by mistake, sometimes by oversight, sometimes by carelessness, sometimes, I dare say, intentionally. And the people who protect individuals against this are the judges, because you protect yourself, you get protected through the courts. Now, the impression given by some newspapers may be that the courts have only been deciding European Union issues and human rights points. But when you turn to the decisions of my court, the Supreme Court, I think fewer than 10% of our decisions involve European Union points, and many of those involve other points as well. And human rights cases are more common, but less than a third of our cases involve human rights, and many of the cases that involve human rights also involve other issues. Interestingly, the most frequent topic in European Union cases we have to deal with is something called the European arrest warrant. This was intended to provide a speedy system whereby people who are wanted in other countries to be prosecuted for an offence can be returned very promptly by the state they're in. So if you've got a person who's wanted by the French prosecution authorities who's in the UK, it's a quick system for the French getting the person back from the UK to be prosecuted. Similarly, if the UK prosecution authorities want somebody who's in France to prosecute him or her, it's a quick way of getting the person back from France. Fundamental to the notion of the warrant is so-called mutual trust and confidence between the two states. If it's an English person wanted in France, the French trust our system to get him there quickly, but we trust the French to prosecute him or her fairly and promptly. And to be honest, with some member states of the European Union, there must be some concern about whether that mutual trust and confidence is entirely justified. But it is inherent in the system. By far the most famous case involving the European arrest warrant that's been in this country, I wasn't involved in it, with the Supreme Court decision involving Julian Assange. The actual issue in his case, on which the Supreme Court split 5-2 against him, was whether the Swedish prosecutor who had issued the warrant asking for his return could really be described as having judicial status so as to justify a UK court extraditing him or returning him. And 5 members of the court thought that he had sufficient judicial status, 2 thought he didn't. I thought I'd mention another couple of cases on human rights. There's a decision in a case called Smith and the Ministry of Defence, which has caused concern in military circles. The issue in that case was whether families of soldiers killed on active service in Iraq or Afghanistan were entitled to pursue claims against the Ministry of Defence for contributing to the deaths of the soldiers by failing to give them adequate protection in the form of proper bomb-proof clothing and proper bomb-proof vehicles. The claims were said to be justified by the wives or families of the soldiers under Article 2 of the Convention on Human Rights, which imposes a duty on the state to take reasonable steps to protect the lives of citizens. The Supreme Court upheld the families' arguments, but there are 2 important points to be made about the decision. First, the court was not holding that their claims should succeed. It was what we call an interlocutory or interim decision. While the case was progressing, we were simply saying, or my colleagues who tried the case were simply saying, that the case was arguable and should go to trial. The second point to be made about the concern of the military was that the family's criticism was not against army officers' decisions on the ground about whether to send somebody out on patrol, but with civil servants' decisions in the Ministry of Defence about what soldiers were to be supplied with in terms of vehicles and clothing, some distance away from the war and some distance, some way away from making urgent battlefield decisions. The second human rights case I was going to mention concerns the vexed question of assisting a suicide. At the moment in this country, assisting a suicide is a crime in this country, however understandable and however well-intentioned the assister motives may be. However kind one is, however much one wants to put somebody help somebody put them out of their pain, assisting a suicide is an offence, even though suicide itself has stopped being an offence more than 50 years ago. In the Nicklinson case, we had to consider the tragic plight of 3 men who had become completely paralysed, or nearly completely paralysed, and could only communicate with great difficulty. In one case, he could communicate only by blinking his eye, and if he blinked it once it meant A, if he blinked it twice it meant B, and so on. So he'd painfully spell out what he wanted to say by blinking. They found somebody developed a computer which could interpret what he said, so you didn't have to sit there and note it, but nonetheless it was the only way he could communicate. These 3 men wished to put an end to their lives. They felt they were pointless, painful, and they just wanted to end it. But of course, because they couldn't move, other than blinking an eye or something similar, they needed somebody to help them. And nobody would help them because their families and the medical people around them and others would have been breaking the law, committing an offence if they helped them commit suicide. And they contended that it was contrary to their rights under Article 8 of the Convention that they couldn't get somebody to help them commit suicide. Article 8 is the right to respect for family life. In effect, it's been interpreted, I think quite rightly, by the Strasbourg Court as the right for individual self-determination. The Strasbourg Court, uncharacteristically, had completely ducked the issue when it went there. They decided that each country should decide on its own law on the topic of assisted suicide. And this was because Strasbourg Court is concerned with about 32 different countries. Some countries are strong Roman Catholic countries that believe suicide is wrong and assisting suicide in any circumstances is completely wrong. Other countries, like Switzerland, not a member of the EU, but signed up to the convention, and Belgium, allow assisted suicide and cater for it in a way which ensures that it's done as humanely as possible. So Strasbourg just decided, Parliament, this is contrary to the Human Rights Convention. Even though Strasbourg had ducked it, we thought we had power to say to Parliament, it's a matter which we, the court, will tell you whether you should be doing or not. But 4 of the 9, 4 of us, thought it was such a controversial and fraught issue that it should be left to Parliament, and that really, even though the court could in theory get involved, it shouldn't get involved, save in the most extreme circumstances. So I wasn't one of the 4, but they had powerful reasons. I didn't agree with them, but that's what they thought. 5 of us thought that there was no reason why the court should not get involved. Of those 5, 3, of which I was one, thought that it was a controversial issue, Parliament should see what our views were and decide what to do, and we would hold fire and not tell Parliament whether it was unlawful or not until they'd had a chance to consider it properly. 2 of us thought that the time had come to say to Parliament, assisting suicide is not consistent with people's human rights, you must do something about it. So we were a bit all over the place. I thought we might get a lot of criticism for not being unanimous, but because all sides in this fraught argument found one or more than one judge to agree with them, everybody seemed quite pleased with our decision, so we were quite lucky. Interestingly, this is a topic that the Canadian Supreme Court had considered last week. And they decided, they're a country with a constitution, they decided that the ban, the blanket ban on assisting suicide, was unlawful, was contrary to the Constitution. So that may be the way the world is starting to go. Another case which is of some interest is one concerned with discrimination, which is, of course, a popular topic in the courts. A significant decision in this area of the court was a case called Bull and Hall. It was a very simple case. A devout Christian couple ran a bed and breakfast business from their home, and they refused to let a gay couple share a double room because they considered sexual activity between people of the same sex to be morally and religiously wrong. The gay couple brought a claim saying they had been unfairly discriminated against. Those sort of decisions, like the decision involving assisted suicide, are difficult partly because there are different moral views, and partly because judges inevitably have their own personal views that you have to divorce as far as you can from your decision making. In that case, we all decided that the law was fairly clear and that the Christian couple were not entitled to exclude the gay couple from sharing a bedroom. Now, I'm not sure, but I'm pretty confident that if they hadn't been running a business, but they just had the gay couple to stay because they were friends, they'd have been quite entitled to say, sorry, if you're staying in our private house, we don't want you to share a bedroom, because that was not a business, that was a private house, and what you do in your private house, you are more free to do as you like. But if you run a business, as they chose to do, albeit in your house, then you have to obey the discrimination law rather more strictly. As I mentioned, we have tended to follow the Strasbourg courts quite closely, but more recently we haven't so much. We have had disagreements with them on two areas, among others. One was a very English view. We took the view that if a landlord or other person owned property and the person who'd been a tenant or was a trespasser now had no right to be there, then they would have no defence and the landlord could simply throw them off by getting a court order. The European Court of Human Rights said, no, if the place is the person's home, then the court has to look at it a bit more carefully, and even though the people who are there may be trespassers, if it's their home, you have to consider whether it's fair and proportionate to evict them. And initially, the House of Lords, which became the Supreme Court, didn't follow what Strasbourg said. But eventually, in one decision, we, as it were, put our hands up and agreed that we would go along with Strasbourg and say that if you were a trespasser, you still had to have your human rights considered before a local authority landlord or public landlord could throw you off. But it required very exceptional facts before somebody who had no right to be on property could be allowed to stay there. And that is where we've got to on that one. Another case where the Strasbourg court accepted our view rather than the other way around involved hearsay evidence being used to convict people. These days, occasionally, inevitably, it happens that witnesses to crimes are intimidated by the accused or the accused family and don't give evidence because they're frightened into not giving evidence. And in certain cases, subject to great restrictions and protections, the English Parliament, the UK Parliament has said that the witness statement of the witness who's not prepared to come along and give evidence can be used in the court. So instead of the witness turning up for the prosecution and being cross-examined by the defence counsel, the court can receive and the jury can look at the witness statement of the witness. And this issue went to the European Court of Human Rights, and they said it does not comply with the right to a fair trial. And the prosecution authorities felt very strongly in this country, they felt it was very unfair because there were all sorts of safeguards included in the statute. And the case came to the Supreme Court. We were invited to follow what Strasbourg said. And we produced a very long, looking at it now, depressingly long judgment explaining why we thought Strasbourg was wrong and that it was all right because of the protection and safeguards accorded to people. And Strasbourg changed its mind and accepted that we were entitled, the UK government was entitled to do that. And there is this dialogue, as it's sometimes called, between the Strasbourg judges and the UK judges carried out through judgments. And in fact, we have the same dialogue with the European Union judges in Luxembourg, but we also meet them and have discussions with them face to face and discuss our concerns. And I think that's quite healthy too. If you just sit there crossly writing judgments, never seeing the people you're writing them at or aiming them at, you're likely to be less understanding of their position, and they're less likely to be understanding of your position than if you meet them and discuss them. Let me turn finally to education. It should be a great thing to be a lawyer, and at least in my experience, it is, and has been. The rule of law is fundamental to a civilized and successful society, and honest, competent, and accessible lawyers are fundamental to the rule of law. So it should be a thoroughly worthwhile job. And the law's got lots of different aspects, and legal practice throws up all sorts of practical, academic, social, and moral issues, which means that it should also be an interesting job. And the law's complex. So clients, whether they're alleged criminals, whether they're divorcing husbands and wives, whether they're oligarchs, whether they're accident victims, they need a lawyer's expertise and experience. And that means that it's also a responsible job. So I think I'd encourage people to consider a legal career, at least to consider it. Of course, like all interesting jobs, there will be boring moments, and of course you can end up in the wrong place. But in general, it is a very good thing to do, a very good career to do in principle. So at the least, you should consider it. Now, I use the cautious lawyer's words, in principle and at the least, because a legal career, of course, doesn't suit everybody. But there are so many different aspects of legal practice that if one job in the law doesn't suit you, another may. So consider it. In every aspect of law, of life, and I'm sure you've all discovered this already, you need luck. You can improve your luck by working hard, and if you're studying for a degree, by getting a good degree. You can improve your luck by investigating the jobs market, the legal jobs market, and by planning ahead, and by getting placements, and so on in solicitors' firms and chambers, and in even placements and jobs in some courts. Nothing in life is guaranteed, but by doing all these things you can improve your prospects. Now, sometimes people wonder, should I study law if I want to be a lawyer? I think there's no right answer to that. If there's no other subject in which you're interested, and then you think you want to be a lawyer, it obviously is a good thing to study law. And if you study law, you will get 3, 2, 4, it depends on the length of the course, years, solid grounding in law, which you don't get if you don't study law at university. And of course, you save time in terms of qualifying if you want to be a practicing lawyer. And law is also a very good mental training. If you don't want to become a lawyer, it's very useful to have studied law. It's good discipline. So there are strong arguments for studying law. Against that, if you're going to be a lawyer all your life doing law, it's quite nice to have done something different before. And if there's something you're really interested in, then I think there's quite a good argument for doing something before you do law. But of course, it holds you back in terms of time, and therefore the cost implications are not so good. I don't think there is a right answer. My experience is that if you ask a lawyer, a successful lawyer, should I study law or something else, you can tell what they did by their answer, because almost always they'll say you should study law if they did, and you shouldn't study law if they didn't. I didn't do law at university. And I half wish I had, because I think I would have had that extra bit of grounding in law at a very impressionable age that would have done me quite a lot of good. Now, what about education itself for lawyers? Well, it's self-evidently the case that lawyers have to be educated in the law. I suppose 300 years ago, you might have understood the whole of the law. The amount of case law, the amount of statute was so small that you could actually grasp it all. Now, if you look just at the volume of primary statutes in force, it's a joke to think anyone could even begin to understand it all, begin to know it all. And when you look at the case law, the statutory instruments, stuff coming from Europe, the volume is absolutely terrifying. So the important thing about learning law, I think, is understanding the basic outlines of legal principles, how the law works, and learning to think like a lawyer. And as I say, even if you don't become a lawyer, it teaches you to think logically and rigorously. And I do think, therefore, studying law is good, because if you're going to be a lawyer, you can actually see the landscape, understand areas of law, and understand the general principles, get legal instincts, which are so important, and so on. Of course, as in any job, almost as important as knowing things is knowing when you're out of your depth, knowing that you don't know something, and knowing where to look so you can learn which books to learn from, which is very important. And that's something also you can learn when you're studying law. What are the standard books on this subject and that subject? Finding your way round law books, finding your way round law reports when you have to look at them, and articles and so on. That is all useful. It's just getting familiar with the material. And a lot of times you go and ask people. If you become a lawyer working in a law firm, you will have partners or other employees or people senior to you, and you just learn to ask them. And in my experience, you shouldn't be afraid to ask. Certainly, remembering my career, when I started, there were some people who were very friendly and very ready to answer questions, and other people who were useless. But when you go to work, you will learn in due course who are the people to ask, and you probably discovered already when you have colleagues you work with or teachers, some of them are more prepared to deal with your questions than others. It's not just a matter of learning law, of course. You have to learn how to deal with practical problems, how to deal with people, and you have to learn ethics. Nobody who's been a lawyer will have avoided the odd case where you are tempted to do something you shouldn't do. Cut a corner, not do something entirely honest because you're so anxious to do the best for your client, breaking a rule, something like that. And I think one of the important trainings for lawyers is don't do that, because the rule of law is fundamental. If lawyers break the rules, what hope is there for anyone else? But as I say, every lawyer will have been tempted from time to time, and sometimes the temptation is quite difficult to resist because it just seems such a small, silly rule and so beneficial for your client, so easy for you if you don't keep to it. I have to admit there probably isn't a lawyer in existence who hasn't broken a rule knowingly, because we're none of us perfect. But you really have to keep to the rules. And on the whole, the professions are quite strict about that. What I was very impressed by in the short talks I heard before I started talking to you was what is done in the way of pro bono law clinics. Because I think, in a way, as important as ethics, as important as knowing the law, is understanding how to deal with people. Because you are having to deal, if you're a solicitor, you've got clients. If you're a barrister, you will have solicitors and the judge to deal with. You've got to understand people. You've got to understand how to deal with people. You can be the best lawyer in the world, but if you can't understand what your client's trying to tell you, and you can't explain to your client what you think he or she should do, it's all useless. And I think the sooner that people start using their law and improving and learning how to deal with people, how to deal with clients, the better. And therefore, law clinics are a terrific thing to do. And also, of course, it's very beneficial for society. In these days, where sadly legal aid is being more and more cut, and the ability for people to get professional legal advice is more and more difficult unless they're very rich, to have law clinics and have people who know a bit about law, maybe not completely qualified always, but actually knowing about law, is very beneficial indeed. So both from your point of view and from the point of view of the public, people out there, it is a very valuable exercise. An organisation that I've seen grow from a tiny organisation to spread across the country is something called the Personal Support Unit. Now that was based in the Royal Courts of Justice and in the Strand, and it helped people who were involved in civil cases, not criminal cases, but civil family cases, bankruptcy, small claims and large claims. And a lot of them couldn't have lawyers, couldn't afford lawyers. And they came to court angry, confused, frightened, tearful, not knowing what to do. And of course, sometimes, even though they didn't have lawyers, they may have had a good point, but they wouldn't have known it. And it's very difficult for a judge to, sometimes you've got a busy list of cases, to deal fairly with somebody who hasn't got a lawyer who can present 3 points of importance or whatever, instead of which you get a sheaf of papers that high and a tearful, inarticulate litigant. The Personal Support Unit is not as good as legal aid, not as good as having a lawyer, but they have people sometimes who are students, sometimes who are retired, sometimes who are not lawyers at all, who, when a litigant in person, i.e. a litigant without a lawyer, comes to court in a state, they will sit them down and talk to them and calm them down and go into court with them. And even if they're not legally qualified, that makes a real difference, and that's very valuable. But if on top of that, like you, most of you here are, you're a lawyer, even if you're a law student, you are able to provide them with help, and at the same time you're helping yourself because you're learning how to deal with people, learning how to listen, and learning how to explain. And that is enormously valuable. So I think that's a vital part of education and a vital part of social responsibility. Can I end by discussing my start as a lawyer? As you will have heard, I had a very privileged upbringing. I went to my father was a professor, a medical professor. I had privileged upbringing, went to private school, so on. But I didn't have it all easy, although nobody should feel sorry for me. I came to law late. I studied science at university. I then went into banking. And I think if I'd stayed more than 3 years in banking, the banking crisis would have happened earlier than it did. I was, to put it bluntly, no good as a scientist or a banker. And I started studying to be a barrister when I was 25, so I was a slightly late entrant. I passed the exams, but I had a shaky start. At that time, it was different at the bar. Now it's difficult to get pupillage because pupillages are paid. Apprentice barristers are paid. So sets of chambers take relatively few pupils who they pay, and it's a big problem getting your foot in the door. In those days, pupillages weren't paid, so there were many more pupillages. It was relatively easy to get them, but it was difficult to translate, or relatively difficult, to move from being an apprentice, from being a pupil, to being a full member of chambers, a full practicing barrister. And I had 3 successive pupillages, each lasting between 3 or 6 months. And at the end of each pupillage, somebody else rather than me was taken on, and I was rejected. It's bad enough being rejected on paper. It's worse being rejected after an interview. But being rejected after you've done 4 months' work in the place is not much fun, I have to say. I nearly gave up when I was turned down the 3rd time, but I decided to give it a last go. And I went slightly down market to a less prestigious set of chambers than the ones I'd been trying for. And it was a case of 4th time lucky. The chambers I joined, although less grand and the ones which rejected me suited me down to the ground. I had 20 years of real enjoyment and great experience until I became a judge. What did I learn from this? Well, first, don't give up too easily. Perseverance can really pay off. I can't promise you that if you hang on there after rejections, you are bound to get taken on eventually. But I do think that if you persevere and show your commitment, you will stand a much better chance of success than if you give up too easily. And my experience in talking to banks who lend money to law students, they confirm this, that even if you don't make it as a practicing lawyer, as I mentioned before, your training as a lawyer will stand you in good stead and is career enhancing. The second thing I learnt was that setbacks, although frightful at the time, can be very good for you. The fact that I found it difficult to get taken on in a set of chambers and start a career as a barrister made me more determined to succeed when I actually got taken on. And I think it made me more appreciative about having the opportunity when I got taken on. And the third thing I learned was that what seem very upsetting and disastrous sometimes events at the time, I still remember my third rejection as being pretty devastating. But that turned out, with wisdom of hindsight, actually to have had great advantages. The set of chambers that rejected me the third time were very good, but I've no doubt that the set I went to instead suited me far, far better. And actually, being rejected was a good thing for me. So having discussed a judge's favourite topic, namely himself, I shall stop. And I'm going to hand over to you to make any points you want to make or any questions you want to ask. And don't be shy about asking anything, whether it's in the talk or whether it's not in the talk. And don't worry about inappropriate questions. I wouldn't go so far as to say there is no such thing as an inappropriate question. But there are very few inappropriate questions. There can be quite a few inappropriate answers. But it's up to me not to give them. So thank you very much indeed.
Thank you very much for that. Now, as you'll have noted, we have the opportunity to ask some questions. But before we get on to that, I'd like to ask one of our alumni who's taken a degree then from this institution onto a very celebrated career, just to respond. Let me introduce Imran Khan. Thank you very much.
I'll be as short as I can, but that's a pretty difficult thing for any lawyer, paid by the hour. I grew up not far from here, in fact about 3 miles from here. I went to a local comprehensive where I got O-levels, some of you may remember those, and then went on to East Ham College, which is not too far from here. And then having been groomed to be a doctor for most of my life, I did A-levels in sciences. And at the end of those, I did what my parents were aghast at. I changed my profession. And instead of going to Bristol or London University to study medicine, I decided to become a lawyer. And then I had to choose where was I going to go and study. So I went to what was called a polytechnic. There's some of you old enough to remember those. And I thought it's in the East End of London, and it would be perfect for me. It would be diverse. It was anything but. It wasn't this grand building, it was the one in Barking. And I went there for many years, and putting aside the diversity aspect, it taught me one crucial thing in my legal career, which is not to accept anything, not to accept any assumptions, to challenge everything. And I had some very good lecturers there who drummed that into me time and time again. And so having got my degree, I then did what was known as the Law Society Finals. And I then, in 1991, I was let into this wonderful profession. I became a fully fledged lawyer. And in those days, and forgive me in front of such esteemed company, the profession was, I've described, having gone into the Law Society chamber in Chancery Lane, And looking at all those oil paintings around the walls, I described the profession as pale, male, and stale. And that's been a continuation for many years. I'll come back to that in a second. Having become a fully fledged solicitor, the first case, in a sense, that landed on my desk was the Stephen Lawrence case. And I'm not taking you through that. But I remembered then, when that case came onto my desk, what I'd learnt at this university. Because everybody was telling me that you can't do anything in this case. There'd been no private prosecution for a racist murder in English legal history, 4 private prosecutions ever. And so the wealth of opinion that was coming to me was, don't do it. It's a nightmare. And it may be that in hindsight, lots of things went wrong, but ultimately it produced a great deal of change in society, of which I'm very proud. And that gave me the opportunity to then become involved in other, what I call impact cases. A case involving Zahid Mubarak, which changed the way prison systems work. Victoria Climbié, which involved child protection. I'm now a partner in my own practice in central London with, I think, I don't know how many, about 50 people. I'm a solicitor advocate doing both the job of a solicitor and appearing in front of Crown Court judges doing murder trials, terrorism trials and the like. I even went to St Kitts 2 weeks ago in the Caribbean to teach and train judges and lawyers out there with 2 judges from this country. What a difficult task in the middle of January. I am living testament to somebody who grew up in a working class area. From working class parents, my father was a bus conductor and then worked at Ford Motor Factory in Dagenham. Went to a comprehensive, went to a polytechnic, and embarked on a career which I hope has been some success. So this university gave me that. So that's the plug for the university. And for some reason, they made me the patron of this clinic. I don't know why. I was an incredibly difficult student. So what can I tell you? What are the things that I can tell you? Before I do that, can I perhaps persuade Lord Neuberger to look at the question of quotas? When I first started out, you had to get experience in your particular field. And when I was instructing a barrister to go into a case, I would look at their CV and say, have you done this, have you done that, have you done the other? And if they hadn't, you wouldn't necessarily choose them. What I didn't know was in barristers' chambers, those individuals, because of racism, weren't getting the opportunities. And everybody makes mistakes when they start off. And people from ethnic minority communities are not given those opportunities to make those mistakes. They're not allowed to go on the first rung of the ladder of opportunity. You've got to get into the door to be able to get that experience to move forward. And so I think, yes, there are those who will think, well, if you're from a quota, you're not up to it. But you know what? I don't think we're there now. There are as many good people from minority communities as there are from others. We just don't get the chance to get our foot in the door. So what's my advice? Well, these were the 4 E's. I'll give you the 3 P's that were given to me by a High Court judge. Preparation, preparation, preparation. Whatever walk of life it is, whether it's your degree, whether it's a court hearing, those 3 words are going to put you in great stead. The unprepared individual is the one that's going to lose in whatever they're going to do. And thirdly, it's a quote that I often get wrong, but I think has stood me in great stead. It comes from a Chinese philosopher many hundreds of years ago, from Confucius, who said that if you enjoy what you do, you'll never work a single day of your life. I haven't worked for the last 25 years. Thank you very much.
Right, well, I'm sure you'll all agree, 2 fantastic speeches there, very interesting. Great, now over to you. Any questions that people want to put to Lord Neuberger? And shall we maybe take a couple at a time? We've got about 20 minutes, I think, in total. You want to start? We've got a microphone somewhere as well.
Justice Neuberger, my name is Paul Dixon, final year law student here at UAI. You mentioned earlier in your question about we need to do some statistical analysis on diversification with female in the judiciary. But if we look in your own domain as President of the Supreme Court, we will see that there are up to 12 justices in the Supreme Court, only one is a female, namely Justice Hale. Now, why is there so much suppression where women is concerned, taking into consideration the Equal Opportunities Act of 2010?
You're absolutely right. There's one woman out of 12. And the answer is, if we had a quota system, it might be different. But we do our best to select, of the applicants, the best who we think has applied. And rightly or wrongly, but according to the law as it stands, we have to choose on merit. And we have chosen the committee, selection committee. It isn't my choice, but I chaired the last selection committee, made the choices that we did. I would want more women, but at the moment, based on merit, maybe the one problem I have about prejudice is the dreaded subject of unconscious or subconscious prejudice. You sit round a table, everybody agrees that you want to increase diversity, you want more women, you want more ethnic minorities. Everybody agrees that, and I'm sure they mean it. What none of us can cater for, and I freely admit I may be guilty of it, as anyone may be, is subconscious, unaware prejudice. I hope I don't suffer from that, and like everyone who makes selections of significance, I have had subconscious prejudice training, awareness training, and I hope that I've been properly trained for it. And I hope that I haven't been prejudiced. I can't stand here and swear I haven't, because by definition I don't know. But I believe that when I've decided, together with the other members of the selection panel, who to select, and I hope and believe that my predecessors, when they made the selection, did it on merit. And as I've said, there is a problem about, as you go up the profession, we are a time-lagging factor, because we reflect the legal profession 15 years, 20 years ago. We have got a lamentable number of women, I accept. We're even worse on ethnic minorities, and I would love to improve it. But I haven't an answer for you in the sense that I can't explain it other than by saying we choose by merit. I believe that we choose according to who we think are the best people, and that's what we've done, and that's the result. I believe that there's an explanation that if we come back in 25 years, when you'll be here, and I probably won't, but if we come back in 25 years, I believe that things will look better. But it's a fair comment, and I have no answer other than the one I've given to it.
In the third row there.
Oh, hello, I'm a first-year law student here. My sort of observations really is around the rulings from Strasbourg. If we adopt sort of a pick and choose sort of method, it seems to me that the government here have sort of translated this into a sort of advisory policy. And what I'm concerned about is the voting rights of prisoners. Yeah? We've had 2 rulings now, and the Hearst case was 10 years ago. Is it likely that prisoners will ever get the right to vote, or will it be just sidelined by this government and you can come in government?
I have to be very careful as a judge what I say about what can be seen as political issues, and particularly so during the present time when there's a lead up to the election. Naturally, any judge, anybody involved with the rule of law would like the law to be obeyed. But equally, we have to accept political realities. Strasbourg has adopted quite a moderate approach. There was a decision yesterday, you probably saw the McHugh decision. They've reaffirmed the fact that by not considering this issue properly and dealing with it properly as they see it, the UK government is in breach of its duties. But on the other hand, they have held that I think there were over 1,000 prisoners who were party to this application. they held that they were not entitled to any compensation or to any costs. I have, like most people, views about this, but I'm afraid there are areas, as I indicated before I started, where judges have to bite their tongues, and I don't think I can say more, but I fully understand what you're saying. You don't have to clap that rather anemic answer.
Thank you for taking my question. I'm from Kingston University. Thank you for the opportunity that I can be here. My question is about European Union, because I think it goes very well with diversity. A lot of the social rights and equal opportunity rights we have here in the UK are by virtue of being members of the Union. And leading up to the election, European Union membership is a hot topic, and I think a lot of people, the everyday citizens, are concerned about political issues. And I notice here a big disengagement within the legal professionals in terms of European Union membership and being part of it. Who do you think should educate these people about their EU rights that they have by virtue of being members of the Union? And don't you think that by allowing people to vote, in no means I'm saying that they should vote yes, let's stay in the Union, but don't you think that there should be someone who starts educating these people? I think initiatives like this, where we engage with everyday people, is brilliant, because then they can find out about it. Do you think that us legal professionals should be more concerned about that?
I think that the topic of the European Union and European Union law is something which gets a lot of anti-Europeans very excited, but the pro-Europeans don't seem to get very excited about it. So the debate has tended to be one-sided. On your specific point about European Union law and its influence here, you are absolutely right. An enormous amount has come into our law in terms of equal opportunities as a result of being members of the European Union, implementing directives and regulations. I think that there is a duty on lawyers and others to make people aware of that, but there's an element of people simply not wanting to know. One of the things that slightly worries me about this country, which I think is generally, when you look at problems across most of the world, a very good country to live in, is that we are almost victims of that, and we take things like the rule of law for granted. As that question about the makeup of the Supreme Court shows, there are things that are less good in this country and we could improve. There's no doubt about that. I don't want to give the impression that everything's wonderful. But because we live in a relatively benign country, I think that we are a bit smug, we just take things for granted. And I think one of the reasons that there are so many vociferous people who don't like the European Union and don't see any benefits from it, and similarly with the Convention, don't see any benefits from it, is that this country has never been, within 300 or 400 years, we've not been invaded, we've not lost democracy, we've not been taken over by a dictator. And you look at the rest of Europe, and the history there is very different. And I think they don't take these things for granted because they realize horrible things can happen if you're not vigilant. And therefore I think you're absolutely right that we're not aware in this country of what we've got and how we've got it. We're not aware of the benefits in some ways of what Europe's done. We listen to all the negatives. And I think that's a fair comment. And I think it's quite difficult to get people actually to listen when you speak in favour, or even explain to them what's been done.
Question in the middle, at the back, in the middle there.
Hi. Hello. There was a survey of judges published earlier this month, I think the results said that something like only half of judges feel valued by the general public, and only 2% of judges feel valued by the government. And I wondered what your thoughts were.
The figures were released didn't include my court. I think, first of all, I think that public service in this country, public servants don't feel particularly valued because of things like pay freezes and so on. Secondly, I think that there is a degree of lack of interest and lack of understanding of the function of the courts and the judges by the government. And I think, to be fair, that can be a two-way process in terms of the judges not always understanding what the government's up to and how the government works. I think I'm sorry that the figure is as low as 2%, but if you told me that 98% of judges felt valued by the government, I would be worried, because I don't think the function of the judiciary is to make the government feel comfortable. While I don't think we should have warfare, heaven forbid, between the judges and the government, I don't think there should be a too cozy relationship. 2% is disturbing. It should be well, disturbing is perhaps a heavy word, but it's concerning. But I think it's understandable. In the Supreme Court, we're slightly detached from the rest of the judiciary. And I think that the Lord Chief Justice, who's responsible for the judiciary, is better able to discuss the detail. But as I say, I wouldn't expect a very high proportion of judges to feel valued by the government, and if they were, I might be slightly concerned. But I would prefer the figure to be higher.
Very good. Okay. On the left at the back there. Luke.
Hi there. My name's David, and I'm at the university. I just had a question about the current state of the legal profession and the current situation we're in with the legal aid cuts. And the current government has gone quite far in cutting in a number of areas of law. Obviously, law clinics like this are great in that they do sort of help certain people with certain areas of law, but it's never ever going to replace a fully funded legal aid system. So I just wanted to get your thoughts on what the legal profession should be doing on trying to, try and maybe get legal aid funding back. Obviously, the ideology of this current government is to cut as many areas as they feel fit, it seems. So do you think that the legal profession should be doing more to try and influence this?
I have to be quite careful in my answer as a judge. I think that picking up the question about what Europe's done and how my answer in terms of how we take things for granted, I think one of the things that we take very much for granted in this country is the rule of law. We always feel we have the rule of law. And I think what one has to remember is one of the most important functions of the rule of law is a citizen, average citizen, having access to courts to exercise his rights or her rights, whether against somebody else, a neighbour, somebody had an accident with, a husband, a wife, a child, whatever, or a claim against the government. And there was a very interesting review of a book in the papers over the weekend. They quoted a chap called Leonard Shapiro, who was a great expert on communist Russia, and he said of all the most important things that distinguishes a democratic society from a tyranny is not free press, free economy, freedom of speech. They're all very important. Elections, very important. but he said the one thing that's most important in his view, after years of studying the Soviet Union and other tyrannies, was a citizen having access to the court to enforce his or her rights. And it is a fundamental right. And the withdrawal of legal aid for most civil and many family cases is of great concern. Now, the government has to decide how to cut if it needs to make cuts, and one appreciates that even legal aid can't be immune. But any sensible person has to be concerned about the cuts. I think that it's wrong to see the government as the only person responsible. As you rightly say, the lawyer, the legal profession, has a responsibility to ensure access to justice, and so do my lot, so do the judges. And one of the problems of our litigation system in this country, when compared with other countries, is that it is very expensive. I was just looking yesterday at a decision of the European Court of Human Rights. It was concerned with the costs in a case in this country between Naomi Campbell and the Mirror, the Daily Mirror. Naomi Campbell had sued the Daily Mirror for showing photographs of her and running a story about her going for drug rehab, and said it was an interference with her human rights. Maybe it's a case I should have mentioned to you because it's quite an interesting case. She said it was an infringement of her privacy, of her private life, and the House of Lords decided, before the days of the Supreme Court, they decided 5-0 that publishing the story about her being on drugs rehab was not an infringement of her privacy, because she had gone public in saying that she never took drugs. So she was entitled to be exposed for not telling quite the truth. But they split 3-2, saying that the photographs were a step too far, showing her going into the drugs rehab place and the clinic, and that was an interference with her rights. Now, she had a special arrangement with her lawyers on costs, and the costs were enormous. And the Daily Mirror took the case to the European Court of Human Rights and said, these sort of costs make access to justice for newspapers unacceptable. And the European Court agreed. But the interesting thing, and this is rather a long story to make a short point, they compared the cost of libel actions in different countries in the various states that were members of the, signed up to the convention. And if my memory is right, this country was the most expensive, Ireland was the second most expensive, and Italy was the third most expensive. But what was shocking was that we were 4 times as much as Ireland, and Ireland was 10 times as much as Italy. Now, there has to be something wrong there. That is not primarily the government's fault. There's something wrong with the system, and that requires the lawyers and judges to do things. We're trying to do things, but we do need to be much more imaginative. The trouble is, we have a system of lawyers and judges and court systems which are fine if you've got claim running into millions of pounds with rich people. Only for £100,000, because if you have a fully fledged trial for £100,000, the cost will be far more if it goes all the way and there's lots of argument and cross-examination. We need to have a system which cuts down the costs. If the costs became less and more manageable, the government may be more prepared to give legal aid. So while I am very concerned about the legal aid, I think there are also things that could and should be done by the lawyers and by the judges, as well as by the government.
Is there one at the back, I think? Yeah, the gentleman slightly in the middle. One couple of
Sir, on the role of judging, having read a lot of judgments, do you think there's any truth in the idea that judges often rule or often decide cases on whether they believe their sense of justice or their sense of legal certainty is sufficiently offended?
I think that's a problem which you have in many cases, is if I want to decide the case for A in favour of A rather than B, because A's behaved very well, it's not his fault, B's behaved very badly. On the other hand, if I decide it that way, I'll be creating a legal precedent that throws the law into an uncertain state and means that for the future, people, when they go to their lawyers with this sort of problem, will be faced with their lawyer saying, well, you could win, you could lose, the law's a bit of a mess. And you often have decisions like that. And I think a truthful answer is that you've got to balance it up and decide in the individual case whether the injustice is particularly great and whether the mess you make of the law will be significant. Some judges are more likely, I think, temperamentally, to be prepared to create problems for the future by doing justice in a particular case. On the whole, I think, maybe I deceive myself, but I tend to be more concerned about getting the law right for the future than doing justice in an individual case. But I think it's much easier when you do what I do, when you're sitting in an appeal court and you haven't seen the witnesses giving evidence and realize how badly behaved B was and how unfairly treated A was. If you're sitting in an appeal court, it's more bloodless, if you like, less emotional. But I think that we do have to remind ourselves often that law, coming back to the previous question, is very expensive and very uncertain. And we want to make it as certain and clear as possible. And therefore, if we have to injustice in a particular case, or not injustice, if we have to produce a result that people will think is unfair in a particular case, in order to make the law clear, that is often a price worth paying. But there are no absolute answers to that.
Draw it to a close. That's good. Yeah, you done. Should we just stop there?
Just one further question.
One more. Yeah. Okay. Okay. We'll take one more. We're slightly over time. How about the lady with the headscarf there in the middle?
Thank you, Lord Neuberger. I was just going to ask a question regarding the future of the Human Rights Act. This government has made very plain that they're not very happy with it. I realise that you don't want to make critical statements, but how important do you think it is to this country, and do you feel there should be more done about preserving it, perhaps in terms of either the legal community being more sort of voice, concern, sort of expressing their concerns about the government's approach, or whether you think the plans of this government, if we get re-elected, the plans for UK civil sort of Bill of Rights and things like that would be enough to sort of be replacing for it.
I think it's an important question, and again I have to be careful what I say for the reasons I've given. But first of all, it's not the present government, it's really the Conservatives, are talking about repealing the Human Rights Act. But it's very difficult to know what to say about it because they propose to replace it with something else, a Bill of Rights. And until one's seen what it is and what it does, it's a bit difficult to comment on it. But I think whether one likes the idea or not, it's fair to say they're not proposing to get rid of human rights altogether. They're merely proposing to have a British version. Now, whether it turns out to be a pretty pallid version or a pretty decent version remains to be seen. Secondly, I think that the effect of the Human Rights Convention being brought into English law, and to UK law indeed, from the perception of a judge who's had a lot to do with it, since becoming a judge, having had nothing to do with it hardly anything to do with it when I was a practicing lawyer, is that it has done a lot of good to our law. And as I say, that's from a judicial point of view. I'm not making a political point. It's enriched our law, it's given us some new ideas, it's protected citizens in a way they've not been protectable by the courts before. But again, as I say, if there is a new set of rules, a new Bill of Rights, they may equally protect. I don't know. May give more protection even. Thirdly, I think there are problems about pulling out of the convention or pulling out of Strasbourg vis-à-vis membership of the European Union. First of all, there may be problems about doing it at all if we remain in the European Union. Secondly, the European Union has the Charter of Fundamental Rights, which we have to sign up to so long as we're members of the Union, that in certain areas give us similar rights anyway. So as I say, my view is wait and see, but it's pretty murky waters, both in terms of what would happen if they did, and whether it's really possible to do, at least so long as we're in the EU.
Okay, I'm afraid I'm going to have to draw this to a close now. Now, I'm sure everybody in here has a very busy and full life. Generally, though, judges are busier than most people. But the President of the Supreme Court, I think we can all agree, is probably redefines what we understand by being a busy person. I'd like to thank him very much for making so much time to us for this evening. Yes, and I think we'll all agree it was a really interesting and thought-provoking speech. So, yes, thank you very much. And we've got then a gesture of our thanks from Naomi Ling and Irene Namby that we'd like to give on to you. Great. Now, there are some refreshments here, so please join us if you'd like something to eat or drink.